From KPRC 2, this is Houston Newsmakers with Cambrell Marshall.
Good morning. The Supreme Court is responsible for establishing the ultimate law of the land, the arbiter, the final arbiter of major legal decisions and disputes in this country. But is it the respected final opinion? And how much have the court's opinions been tarnished by partisanship, something that's been a subtle part of opinions through the years sometimes, but now seems very much out in the open? Voting Rights Act, now in the forefront of news these days because of efforts in Congress to get it recertified, has been shaped by the Supreme Court in recent years. Joining me this morning is someone who knows quite a bit about the Supreme Court's decisions, Professor Emily Berman from the University of Houston Law Center, who teaches constitutional law as well as foreign affairs and national security law. Good morning to you. Thank you so much for your time this morning. Let me ask you this. The Supreme Court, the makeup of the Supreme Court changes through the years. We know that. But it seems to have tilted much more in political ways than it has in the past. Is that an accurate assessment, or have there been other similar circumstances where it's tilted as much?
The Supreme Court it's been somewhat of a pendulum through the course of American history, leaning one way during some periods and then turning back the other way. But those ideological changes are often gradual, whereas the lean toward the right that we are experiencing now might seem a bit more precipitous than what we're used to. There is at least one other famous instance of the Supreme Court really flipping seemingly overnight, but it was a shift in the opposite direction from a conservative court to a more progressive one. And that was during the Great Depression. The court was narrowly divided. And in the early 30s, the court tended to be more aggressive in striking down the major programs that FDR was trying to put into place to combat the Great Depression. And frustrated by the court striking down his policies, FDR announced a plan to add justices to the Supreme Court. This is the so-called famous court packing plan, to ensure that there would be a majority that favored his policies. And after he'd announced in the following year, one of the justices on the court started switching his vote and voting in favor of upholding FDR's policy. So that switch in that one particular justice's ideological leanings is often referred to as the switch in time that saved the nine, because it maintained the 9-justice Supreme Court. And, you know, scholars continue to debate whether that switch was a result of pressure imposed by FDR's court packing plan or whether there's some other explanation for it. You know, today's shift has been due more to changing personnel on the court rather than the change of opinion of any particular justice. But for those of us living through these times, it, I think, feels sort of similarly sudden.
Well, the primary focus in Congress these days is recertification of the Voting Rights Act. Let's talk about that for a second, because it seems to me it's safe to say that we wouldn't even be having these fights were it not for the Supreme Court's decision in Shelby versus Holder in 2013 that many say weakened the Voting Rights Act, correct?
Yeah, absolutely. So what the court did in the Shelby County case is strike down a provision of the Voting Rights Act of 1965 that required jurisdictions with a history of racially discriminatory election rules to what's called pre-clear any changes to their rules, either through the Department of Justice or through a federal judge. So the idea was anytime one of these state or local governments wanted to change the way they run elections, somebody had to look at it and make sure that it wasn't going to revert back to rules that had racially discriminatory impacts on ethnic and racial minorities. And the rule was first passed in 1965, but it had been reaffirmed and extended through the years, usually by unanimous Congresses, 4 times since then, most recently in 2006. But then in 2013, the Supreme Court decided that the pre-clearance requirement was no longer justified by the conditions on the ground, and struck down the provision that required pre-clearance. And that pre-clearance requirement had applied to everything from voter ID laws to modifying voter registration processes to changing the location of polling places. And as soon as that pre-clearance requirement was eliminated, we saw a flood of new election laws. Just to Texas, for an example, in 2012, Texas was barred from implementing its new voter ID requirement because a federal court determined that Texas that it wouldn't discriminate against Black and Latino voters. Within 24 hours of the Shelby County case, then Attorney General Greg Abbott announced that law would be implemented and enforced, and several other states followed suit. So the John Lewis Voting Rights Advancement Act sought to re-implement this pre-clearance requirement, but of course, as we saw this week, it failed to clear the Senate, and so that leaves the field open, making it much more easy for states to change their laws. Well,
I find the Supreme Court and the way it's acted over the past years fascinating. We've got more to talk about. I love this. That's why we bring professors like Professor Berman on, because we can learn a whole lot. We're going to talk more about it, and we'll continue our conversation on Houston Newsmakers Extra. You can go to that on the Newsmakers page on clicktohouston.com. Move over to that website after this program to join us.